Alexia Torkey. I direct the fellowship at the Fairbanks Center, and it's my pleasure to welcome all of you to the Fairbanks Ethics Lecture Series. I want to let you know with a few housekeeping items before I introduce Dr. Comer. So applications are now available for the 2016-17 Clinical Ethics Fellowship, and a flyer with information can be found at the sign-up table, and you can also look on our website. This lecture is being recorded and broadcast today, so thanks to those of you joining from IU Health Ball Memorial, West, Arnett, and Blackford hospitals. Please silence your cell phones and electronic devices, and if you need to answer a call, please leave the auditorium to do so. There are phones located in the hall across in the coat closet if you need them. And finally, our speaker today has no conflicts of interest to disclose. So now it is my pleasure to introduce our speaker, Dr. Amber Comer. She's an assistant professor in the Indiana University School of Health and Rehabilitation Sciences in the Department of Health Sciences. She obtained her JD from the Indiana University McKinney School of Law and her PhD from the Fairbanks School of Public Health. In addition to her graduate education, we got to know her when she completed a medical ethics fellowship at the IU Health Fairbanks Center for Medical Ethics. She also holds an adjunct appointment at the McKinney School of Law, where she teaches a health law class. She is an affiliated research scientist at the IU School of Medicine's Regan Street Institute, and she serves on the Eskenazi Health Medical Ethics Committee. I've had the pleasure of working with Dr. Comer over the past few years on some of her incredibly interesting research addressing who can make decisions for incapacitated adults. So please join me in welcoming Amber.
Hi, I'm so glad all of you could join me today. I think that regardless of the area that you work in with patients, this is a relevant conversation that needs to be had. So just to give you a little bit of background about this presentation I'm giving you today, this actually started as my fellowship project when I was a medical ethics fellow, and Dr. Torkey was actually my mentor on that. So she's been with me through all of the stages of this. And so it started as my fellowship project, and what happened is when I took medical ethics call, I kept getting called in to see patients over and over again where they had issues where they either had too many surrogates who were making decisions and there was no final decision maker, which caused conflict among the families, or there were people that were loving and caring and knew what the patient wanted, but they weren't legal under Indiana law, and so they couldn't actually make the final decision for the patient. So from this, I started to wonder, how often does this happen? And when I started seeing it over and over again, I realized, well, maybe we need to see whether or not Indiana's law is really doing the best that it can for our patients in hospitals. And so this started out of a fellowship project to see how Indiana's law was doing and whether it was actually working. And then it expanded into my PhD doctoral dissertation. And so from there, I conducted a study, which was broken into 3 parts, and I'm going to actually share the results of that study with you today. But before I get to the study, I want to give you a little bit of background information on how healthcare consent actually works in the state of Indiana, because that's the educational piece. So to begin with, I want to acknowledge the Indiana University Fairbanks Center for Medical Ethics, who helped fund my study and who also gave me the incredible opportunity to be a fellow. So fellowship applications are open to here. It is one of the best experiences that I've ever had in my life, and I wish I could do it over again if they take me, but I hear I can't. So the Indiana University Center for Aging Research, who also helped with funding of the project, and then contributors, Dr. Alexia Torkey, who's been with me. She was my mentor through the fellowship, and then she served on my doctoral dissertation program and continues to be my mentor in my research today. And Dr. Margaret Gaffney, Cindy Stone, Jason Everell, and Ross Silverman, who also served on my doctoral dissertation committee. And so they are one of 6 people who have read my dissertation. So, but I'm going to share the highlights with you guys today. So what are surrogate decisions? So typically when I say I do research in surrogate decisions, the first thing people say back to me is, oh, you're talking about babies and women having other people's babies. And my response is, no, not exactly. So that what surrogate decision makers are is they are someone who makes decisions for a patient when they're medically incapacitated and they can't speak for themselves. So, and this doesn't mean that the patient has no ability to speak. This could mean that the patient just needs help being able to recognize what they may or may not want. Maybe they are waxing and waning, they're in and out. So I want to take a moment and talk about capacity versus competency first. So capacity is actually a medical term. Capacity is something that can wax and wane. A patient can be say they're in the ICU. They can have moments where they're very lucid and they're able to make decisions for themselves. And then there's moments where they really can't make decisions and they need someone to step in and help. So capacity is actually something that a medical professional would be the one who would determine. So any physician can decide whether someone has capacity. Typically, this gets passed on to the neurologists or the psychologists, but it can really be any physician. So that's capacity. It's medical in nature. It's done in the hospital at the patient's bedside. And then there's competency. So competency is actually a legal term, and that's adjudicated, and it's adjudicated by a court of law. So if you have someone, for instance, who has a mental illness and is unable to take care of themselves and make decisions for themselves, a judge would render that person incompetent to make decisions and would appoint a surrogate decision maker. So that is something that does not wax and wane. Once you are adjudicated incompetent, your surrogate has the ability to make your decisions for you. That's not to say that you shouldn't talk to the patient, but it is a very different term. It's legal in nature. So today we're actually going to talk about patients who are incapacitated. So this is the medical side of things. So a study done by Dr. Alexia Torkey and colleagues found that was published in the Journal of the American Medical Association Internal Medicine, found that approximately 47.4% of older adults in Indiana require a surrogate decision maker. So that's a lot of people who need help making medical decisions. So how do we find out when we're in care, when you're taking care of a patient and you're at the bedside and you're looking at 3 people who refuse to leave the room and all have their own opinion on what should happen to the patient? How do you determine who the person is who should actually be making the decisions for the patient? So that's what we're going to find out today. So legal surrogate decision makers can actually be identified in several different ways. So the first way is appointment by the patient prior to incapacitation through a legal document such as a healthcare power of attorney, a healthcare representative form, an advance directive, living will, or a post form. And I will tell you, I'm going to go through what each of these means and what's required to actually have these forms. So if you're not sure what something is or what the difference is, or you had no idea that in the state of Indiana there's a difference between a healthcare power of attorney and a healthcare representative form, today's your opportunity to learn. So if you don't have one of these forms, so if the patient didn't know that they needed to fill out a form, they just thought that the person who loved them would make their decisions, then you would actually default to the state healthcare consent law, unless you have a court-adjudicated guardianship. There's the word. So a guardian. So a guardian is court-adjudicated. So the interesting thing is that studies are actually find that between 5 and 20% of patients show up with one of these forms to the hospital. That's not a lot of patients. And if you go through the records, not very many patients, even if they've made a healthcare form at home, they don't typically bring it into the hospital with them. So what we find is that most patients are actually going to rely on Indiana's default surrogate healthcare consent law. But before we get to that law, I'm going to talk a little bit about what each of these different forms means. So first, there's healthcare power of attorney. So this is actually, this has the most power. So with a healthcare power of attorney, it allows the patient to name their surrogate decision maker, and that can be anyone that they so choose, from their spouse to their parent. It could be their maid if they wanted it to be. Whoever that patient thinks knows them the best and is going to make the decision that's best for them. So it also allows the surrogate to make decisions regarding release from the hospital or healthcare facility and disposition of the patient's body. So it also allows the surrogate to have access to medical records. So it yields a lot of power. So before you appoint someone as your healthcare power of attorney, you'd want to make sure that you truly trust them and that they're going to do what's best for you. So because this yields the most power, it actually requires the most amount of work to have it filled out. So it requires a notarization and a witness that is not the surrogate that's being appointed. So you have to actually go and find a notary, which you can actually find at any bank. Sometimes there's notaries running around the hospital. So, but it does require more work. So less patients tend to have these on file. So then we have a healthcare representative form. This is something that you can actually find if you look like you're all wearing IU Health badges. You can find it on the Pulse page. There's actually an IU Health healthcare representative form. And all it requires is a witness's signature. So a nurse can sign as the witness. You can sign as the witness. Anyone who's not the surrogate. So it doesn't require a notary. This can be done at the patient's bedside during a point where the patient's lucid and has capacity to make their own decisions. So this allows you to make a surrogate decision maker and allows the surrogate to make the decisions, the healthcare decisions for the patient. It does not technically yield the power to allow that surrogate to get medical records, to transfer the patient, to discharge the patient, or to dispose of the patient's body should they pass away. So it does not yield as much power as a healthcare power of attorney form. So if you were going to advise someone which one to get, take the extra step and get the notary, because then that assures that your surrogate has the power to do the things that you need them to do. So next is an advance directive. So an advance directive is a term that people use usually to refer to a living will or a healthcare representative form, but it actually is a combination of these two documents. So an advance directive is actually a living will coupled with a healthcare power of attorney or healthcare representative form. If you have both of these things, you then have an advance directive. A living will is a document where a patient states his or her wishes about life support and other medical treatments. So a living will can be something that's very simple, or a living will is something that can be extremely in-depth. So this is an example of a living will that actually comes from Indiana's code. And I can tell you that this is the simplest living will that's out there, and there's actually a form that the state of Indiana provides that says you can choose how you want your health care. And so I guess a fun game to play is, as healthcare providers, let's go through this and see if you would actually know what the patient wanted. So I wish to receive artificially supplied nutrition and hydration, even if the effort to sustain life is futile or excessively burdensome to me. So that's saying I want everything regardless of what you think. So you better give it to me. So that's the patient's wish. The next box they can check is, I do not wish to receive artificially supplied nutrition and hydration if the effort to sustain life is futile and excessively burdensome to me. So now you have to decide what is futile and excessively burdensome to a patient that's lacking capacity that you probably don't have an established relationship with if they're in the hospital. So it doesn't really say a lot, or maybe it says everything. I don't know. That's your guys' job to figure out. So then you can actually say, I intentionally make no decision concerning artificially supplied nutrition and hydration, leaving that decision to my healthcare representative, an attorney in fact. So they can say, I don't even want to make this decision, go to my surrogate. They'll tell you what I want. So this is a pretty simple living will, where you're trying to give some idea of what you may or may not want, which it can be very helpful if you're coming down to, gosh, I don't know if we should remove the ventilator from this patient. And if they had checked the first box, then you would say, maybe we shouldn't remove the ventilator. It looks like they would have wanted that. So the thing about a living will is that even though the patient is trying to retain their autonomous decision-making when they can't speak for themselves, a living will is actually not a legally binding document. It is more of a suggestion. In fact, there is only one state in the United States that actually protects healthcare providers who choose to follow a living will over what the surrogate wants. And that's the state of Texas. So in the state of Texas, if there is a living will in the physician's hand and it says, I do not want to be I don't want to be trached and pegged, then the physician can actually choose not to trach and peg that patient, even over the objection of every family member standing at the patient's bedside, and they are actually immune from being sued. The state of Indiana does not have that provision in our law, so a living will is actually more of a recommendation than a legally binding document. Now, ethically, you would say that you have a responsibility to try to uphold the patient's autonomy. If the patient went through the effort to try to fill out a living will, as hard as it may be to interpret what this means, you still have an ethical obligation to try to follow what the patient may want. So you can see how this is actually going to arise in a dilemma at the patient's bedside when you have a living will saying one thing and you have family members wanting totally different care for the patient. So then there's something in Indiana which you may or may not have seen, but is actually a legally binding document, and it's called the Life Prolonging Procedures Declaration. And it's a document that patients can access on the state of Indiana's website, and it actually is something they sign that says, I want the use of prolonging procedures that would extend my life under all circumstances. This includes appropriate nutrition and hydration, the administration of medication, and the performance of all other medical procedures necessary to extend my life, to provide comfort care, or to alleviate pain. And this does not require a notary, but it does require 2 witnesses' signatures. So if you had a patient who had this form, then I guess it doesn't leave a lot of questions to be asked. You know exactly what to do. You have to give them everything. But then that gets into a whole lot of other ethical conversations where maybe physicians and nurses and other caregivers don't feel comfortable giving the patient care anymore because they think that the patient's actually suffering. And so this can actually bring up a lot of ethical problems at the patient's bedside when it's actually implemented. I have not really come across, has anyone come across one of these in their practice? Just a couple. So notice everyone who's come across them is on the ethics committee, probably because it begs the question of an ethics consult once the caregivers feel that the care is no longer medically necessary and may actually be a form of medical torture or is causing the patient pain and suffering. So then we have a post form, and this is our newest form that's been implemented that patients can use when they're terminally ill within 6 months of death, where they can make medical decisions, where they can state their preferences. So they can say, I prefer comfort care, I do or do not prefer hospitalization, I do or do not want intubation, I do or do not want antibiotics, or maybe you want antibiotics but for comfort care only, and I do or do not want artificial nutrition, artificial resuscitation. And this is a form that a patient would fill out with their family member. And this actually came to Indiana because of Susan Hickman, who's with us, because of her efforts. And so this is our newest form that can be used in a hospital to try to have patients say, this is what I do or do not want. And it's a pretty straightforward way for both the caregiver and the patient's family to understand the patient's wishes. It doesn't really leave a lot of questions the way some of the living will forms do. So then there's guardianship. So this is court adjudicated. So if a patient's family member comes in or a patient's loved one comes in and says, I am the court-appointed guardian, then this means that they've actually gone to court and a judge has said that this patient lacks competency. So that's that legal term, competency. And so this actually yields more authority than a healthcare power of attorney or healthcare representative form because someone who's the patient's legal guardian has the ability to deal with other affairs outside of just the hospital. So even though there are all of these ways that a patient can appoint someone to make their decisions for them, we still find that the overwhelming majority of patients, almost all patients when you look at the studies, are going to default to the state surrogate decision-making law. So this law is extremely important because it is what it's actually, it's what actually decides who makes your decisions. So in the state of Indiana, our law says that your spouse, your parent, your adult child, and your adult sibling can all make your decisions for you. And we do not have a hierarchy. So these people actually all yield the exact same amount of power. We do not have a majority rules clause in our state, meaning that all of these people actually have to come to a consensus in order for care to proceed with the patient. So what we usually find in the state of Indiana is that patients either have too many decision makers, and that leads to family disputes and arguments because you have your spouse fighting with the parent who's maybe fighting with, it always seems to be the brother or sister from across the country that flies in at the last minute. You guys, everybody's on the same page, everybody's ready to go, they know it's the patient's time, and they're getting ready to remove the ventilator, and then all of a sudden you have a sibling who's, no, you can't do that, you have to fight harder. You can't quit, you can't give up. And so then that leads to more conversations and maybe a different care outcome. It just depends on the situation. So the other situation that we find because of our state law is that patients have no one to make their decision. So there is actually, according to the literature, 16% of patients who are what we call unbefriended, meaning they have no one. Now these unbefriended patients, there is actually a system in place, at least in Indianapolis, where people can volunteer to be a guardian, and they can make the medical decisions for these patients. But what we're talking about with our state law isn't even the unbefriended. We're talking about the patients who have a loving, caring person at the bedside, but the law doesn't recognize them as being someone who can legally make decisions. So a good example of this, in the United States, according to our last census, we had 7.5 million grandparent-grandchildren pairs who were each other's primary caregiver, one way or the other. In the state of Indiana, if an adult grandchild is the primary caregiver of their grandparent at home and they've been taking care of them for 3 years, living with them, doing everything for them, making all of their decisions, if that grandparent is admitted to the hospital and they do not have one of those healthcare forms that we talked about, that grandchild has no legal they have no legal right to be making medical decisions for that grandparent. And the same goes for a grandchild. So maybe a grandchild was raised by a grandparent, but now the grandchild is an adult. They're 18. They get in a car accident. The grandparent has been their parent, in essence, their entire life. They have no legal decision-making authority in Indiana. Another one that you will probably come across or have come across is people who are in long-term relationships but have chosen not to get married. So there is, according to the census, I can't actually remember that number off the top of my head, so I will not misquote it, but there are millions of people who are choosing not to get married anymore. It seems to be the trend among the millennials, who I'm going to say I'm not one of. They don't want to get married, so they're not. But they've been with someone for 5 years, 7 years, 10 years. And in Indiana, we don't recognize common law marriage. So because we don't recognize common law marriage, these people, regardless of how long you've been with that person, no legal ability to make decisions in the state of Indiana. So prior to last summer, when the Supreme Court of the United States, do you have a question? Does this? No, it does not. That's a great question. So this does not. So that's an excellent point to make. So this is actually the default. So if you do not have a court-appointed guardian, which is actually number one on the list, if you do not have a healthcare power of attorney form, and then if you do not have a healthcare representative form, or you do not have a post, then you would turn to the surrogate decision-making statute. So this is the default. But even though we have all of these other mechanisms for people to appoint surrogate decision makers, we find that most people end up the decision comes down to the default statute. So, okay, let's see where we at. So, tons of ways that, gay marriage. Prior to the United States Supreme Court's ruling last summer stating that gay marriage was considered legal in all 50 states, Indiana wouldn't recognize if someone were married in, say, Vermont and had a legally binding marriage in Vermont but was living in Indiana. And so many, many different examples of how under Indiana's law, without those proper forms filled out, people are left without someone to make their legal decisions for them. And in the event that you have someone who's a loving, caring, ethically appropriate person to be making your decisions at your bedside, and they don't qualify under the law, you have to actually go to court and pursue a guardianship. So pursuing a guardianship is actually costly, and it's time-consuming, and it delays patient care. So now we're going to talk. Yeah, sure. Well, it is, but you have to have, absolutely. So the question being, if someone is they're married in Vermont, but that marriage was not recognized in Indiana, would a healthcare power of attorney be recognized? And the answer is yes. So that is why it is great to have the wherewithal to have these forms filled out. But as the study suggests, people don't have them filled out. And that's actually, by the way, even after in 1990, the Patient Self-Determination Act was passed, which actually said all healthcare facilities receiving Medicare and Medicaid reimbursements had to actually ask patients if they had an advance directive, and if not, did they want help making one. So there are mechanisms out there to ask people, do you want to appoint a surrogate? And yet people still are not appointing surrogates, mostly because they assume that the person who they would want making their decisions will be legally able to make their decisions if something were to happen to them. So this is a summary to show you that Indiana state law is not common. In fact, it is actually unique among state surrogate decision-making laws in the country. So the first part of our law, very common, the ability for spouses, adult children, parents, adult siblings to make decisions for someone, very common in all states that have surrogate decision-making statutes. But what you'll see is that in other states, they allow other people. So 23 states allow close friends. This tends to be a catch-all provision that tends to be at the bottom of what they call a hierarchy of decision makers. So what will happen in these states, states like Illinois, just next door, actually at the VA hospital, which we have here in Indianapolis, they have their own surrogate decision-making law that is separate from Indiana surrogate decision-making law, for those of you who practice at the VA. It actually says the spouse is first, the children are second, the parents are third, the siblings are fourth, and then if you don't have any of those immediate family members, it gets all the way down to a close friend. So that is actually a way that you can catch if someone's in a common law, what they consider to be a common law marriage that isn't recognized in your state. You've been together 10 years. 15 years, you never got married. You would actually qualify as a close friend, and you would actually have the ability to make the decisions for the patient at their bedside. This would also qualify what we're finding in a lot of elderly people, which is going to be one of the biggest populations of people now that we have the baby boomers, is that we're finding really high divorce rates. So there's an entire area in law of just looking at family law in older people who are getting divorced. So now they're divorced. Maybe they have grown children or they never had children. At that point, they're losing their immediate family members to death, disease, whatever it may be, and they're left without surrogates. So we're finding them to be left without someone to make their decisions at high rates. But they may have a very close friend. And this is actually the story that inspired this entire study, was an elderly woman whose husband had passed away. She had no immediate family, but she did have a close friend that she had been friends with for 20 years, who she wanted to make her decisions for her. And this person knew what she would have wanted. So other states, they try to line everyone up they possibly can. They start talking about aunts and uncles. There's one state that actually talks about cousins. There are states that will try to say stepchildren, step-parents, but other states will just say close friend or other family member to try to encompass everything without trying to play the guessing game of who could possibly be making decisions. So another thing I want to point out from this is that there are 30 states that actually have a hierarchy of final decision makers. So that what the hierarchy means is and it's written differently in different state laws, but in essence, the notion is you have all these people who can make decisions. It doesn't mean that these people should not have a conversation about what the patient would have wanted. But if in the event that these family members cannot reach a consensus, there is one final decision maker who can actually step forward and say, you know, I've examined the evidence, I've heard what everybody has to say, but this is how we're going to move forward. So without the hierarchy, you end up in situations where everyone has to reach consensus. And then you end up in situations where you can have family members who come out of the woodwork at the last minute. So 30 states have this hierarchy of final decision makers. So now what I'm going to do is I'm going to tell you a little bit about my study and what I did. And the study was actually a survey of Indiana physicians. And I asked Indiana physicians numerous questions to try to get at how is our law actually working in practice. So the first question that I asked was, I asked physicians to identify decision makers under the law. So you guys can kind of play along at home, but I asked the question. An adult patient is incapacitated and unable to make his or her own medical decisions. The patient has not completed a healthcare power of attorney or healthcare representative form. Which of the following people are permitted to make medical decisions for the patient under Indiana law? Check all that apply. So you can raise your hand as we go along, but spouses, yeah, paying it, there should be all hands for paying attention. Adult children, that's right. Civil partner, okay. Live-in boyfriend or girlfriend, a parent, yeah. Adult sibling, looking good. Niece or nephew. Oh, what about a grandchild? But I've been taking care of my grandmother for 3 years. I am the only family member she has. What do you mean I can't make her decisions? You're not going to let me? Guys, this is a hard audience. How about a close friend? Yeah, so that's okay. We're gonna get to that. It's okay. So the next question just basically asks, if there's a dispute among these family members or among the decision makers, who actually has the final say? So in the state of Indiana, who has the final say? Yeah, right, exactly. It's all of the family members share equal decision-making authority. And then the last question was, if there is a dispute and it cannot be reconciled, what's the next step? And the next step, of course, is guardianship. But this was to see if physicians knew that. So the next set of questions was actually aimed at more at looking at what are physicians doing in practice? And the thought behind this set of questions is that there's 4 scenarios here looking at 4 different types of situations where a surrogate may want to speak for a patient. So the first one's looking at an elderly widow whose only child has died, and her granddaughter's been taking care of her for the past 5 years and is always present at the bedside. The patient needs a procedure which requires informed consent. Would you allow the granddaughter to consent to the procedure? So how many of you in clinical practice would actually allow that? I am not the police, by the way. So this is getting at there may be something more here than just the law. This sounds like a very ethically acceptable surrogate. This patient seems to know the surrogate seems to know what the patient wants. They're in a loving, caring relationship. This is the patient's primary caregiver at home. Yet our law doesn't support this grandchild being able to make decisions. So I think that the nice thing is that this was an anonymous survey, so no one felt like they were being policed. So I'll give you the answers of what your fellow colleagues said after we get through the questions. So the next one was looking at people who were a gay man who was estranged from his family and his partner of 25 years wanted to make decisions for him. The next one was a homeless patient. He had no friends or family, but he did have someone who considered himself to be the patient's brother because they'd been together through everything. And the last one was a divorced woman of 60 years, but since her divorce, she'd been living with a man for 20 years who she considered to be her common-law husband. Never thought of him as anything other than her common-law husband, and he wanted to make her decisions. So the question was, would you allow these people to make the decisions in clinical practice? So now I'm going to tell you how your colleagues answered. Okay. So the study population included 412 physicians who are currently practicing in Indiana hospitals. I excluded pathologists and radiologists because they don't tend to actually have contact with patients, so I didn't think they'd be good people to ask. So you can see that by medical specialty, we included different people from different medical specialties, but we were able to get a response from the people who come across these decisions the most. We had physicians that have been licensed for at different points in their career, and we had with males and females, that actually equates to the number of males and females who are actually practicing medicine. So this actually turns out to be 30% of all physicians who work in Indiana hospitals who responded to the survey. So this is a really very generalizable result set. So now here's the results. It's what you guys have been waiting for. I felt like I should have done like a drum roll before I said it. But okay, we've got physicians with accurate knowledge of the law. How many physicians know the law? 48%. That's it. So less than half of physicians knew the law. So physicians who correctly identified that there's no hierarchy of decision makers, not even 15%. So it seems to be the common assumption among physicians that there is a hierarchy in Indiana. So if it isn't causing a problem, we can maybe make the assumption it's because we've already been operating as if there is a hierarchy, even though that is not the law. So physicians who identified that pursuing a guardianship is the correct legal action, 57.5%. So more than half knew that you should get a guardianship if you couldn't reach a consensus. So they were better in that area than other areas. So this slide is looking at the frequency that physicians believed a surrogate was legal. So maybe they didn't know the law, but let's see who they actually thought could make decisions. So what's interesting is that the first four, the spouse, adult children, parent, adult sibling, physicians were pretty accurate in identifying that these are legal surrogate decision makers. But the other four, only 5% of physicians thought that close friends could make decisions, and only 16.5% thought that grandchildren could make decisions. And this is a very important number I want you to remember. 16.5% of physicians thought that it was legal. That's it. The rest of them knew it wasn't legal. They didn't identify that they thought that was a legal surrogate. That's important because when you get to the question of should the grandchild consent for the grandparent, we have the overwhelming response of, yes, I allow that in clinical practice. So now you can see that ethics and law are sort of competing here. You have physicians who are saying, maybe they're actively saying, I'm not going to follow the law. I can't really speak for them. All I can do is try to channel them. And so there are different reasons for this. One, because ethically, this is an ethically acceptable surrogate, and why should we force this person, this loving, caring patient at the surrogate at the patient's bedside, to go to court and get a guardianship? The other might be just sheer convenience. It's going to delay care. It's going to take up a bed. It's going to make things a lot harder around here if we don't just let this person consent. So there's many different reasons, but I would like to think it's because all of us have this ethical code that we're following, and that we just can't bear to see an ethically acceptable surrogate be turned away. So you can see that here we have all physicians on the left. So this is all physicians, regardless if they knew the law. So the second column is actually only physicians, that 48%, who could correctly identify that they knew the law. So here you can see that 92% of physicians who knew the law said that they would allow grandchildren to consent. 41% of physicians who knew the law said they'd let unmarried common law partners make decisions. 40% said that they would allow same-sex partners, and almost 20% said that they would allow close friends. So what we can see is that physicians who know the law don't follow the law. So another question that was asked was actually looking at the length of delay in care. And so physicians were asked, how many times in the last year have you experienced a delay in patient care because you couldn't identify an appropriate surrogate? And what we found is that more than half of physicians actually experienced a delay in care because they couldn't legally identify a surrogate. So maybe there's somebody there, but they weren't legal under the law. Or maybe the patient was unbefriended, but more than half of physicians experienced a delay. So this is important because, well, first off, if half of physicians are experiencing a delay, but almost all of them are choosing to violate the law at times, this could actually be a much bigger problem if we actually enforce the law. So you can see that this is capturing if they don't follow the law, then they're still having delay. So what I've done with this research is after I did this research study, I've actually been working with the Indiana State Medical Association to try to change Indiana's law, because what I found is that it's not working in practice, and that there are ethically defensible, ethically acceptable surrogates who should be able to make decisions for the patient who are not being able to speak, and they're being silenced because of our law. So what I'd like to do is actually expand the list of allowable surrogates. And so this past session, Senate Bill 193 was proposed. It didn't gain as much traction as we had hoped. So we're going to try again next year. So that's where we're at. So in the meantime, you can try to advise your patients to try to fill out those healthcare representative forms at least, because they can do that in the hospital with just one witness. And you can also help us in our initiative to try to get the law changed, to try to expand the list of decision makers. So at this point, I have time I can take questions. Yeah.
Can you wait for the mic, please? Sorry.
Didn't Senate Bill 193 also propose a hierarchy in addition to expanding the list?
Yes. So the question is, did it propose a hierarchy? And the answer is yes, because there actually isn't a way to expand the list without implementing some sort of hierarchy. Otherwise, you would just have mass confusion if everybody had equal say. So you can't actually say, yeah, okay, fine, we'll allow grandchildren, maybe we'll allow other relatives, maybe common law marriage, but if you don't establish that hierarchy, then everybody's on an equal playing field. So there actually isn't a way to do it. Now, I did have a solution that's a little bit different than what was proposed in Senate Bill 193. And my thought is that because Indiana is worried about people not having a conversation, what if we left the current decision makers, the spouse, parents, adult siblings, adult children, we left them on an equal playing field and then added people below them in the hierarchy and then maybe put in a clause for dispute resolution. Because that way you're still having these conversations, but there's at least a way to resolve it within the hospital without requiring people to go to court. Which, by the way, the courts have said over and over again, they do not want to be involved in these decisions. They want these to be taken care of in the hospital.
So this is a pragmatic question. We don't typically ask people for a copy of their marriage license or their birth certificate or anything else. We literally take people at their word.
Sure.
What feedback or thoughts do you have for clinicians who maybe sort of kind of know that the person's not on the list, but as long as they don't actually disclose what their technical relationship is? I mean, how do you recommend we navigate this? Because we don't ask.
Sure, that's a really valid point. So under Indiana law, physicians are supposed to determine who the surrogate is, and they just have to give good faith. In good faith, they believed that was actually the decision maker. So no, you're not required to ask for a marriage certificate. And in fact, if you started asking some people but not other people, they might, have a civil rights action on their hands because they're saying you're discriminating against them. Why would you ask me but not them? As long as it's a good faith effort, that's all the law says. So if in good faith you say, yeah, they seem like they're siblings, then I guess you're all right.
So state laws will vary state to state, but does the medical power of attorney rule, and in the absence of that, I guess a guardian,
I'm so sorry, I couldn't hear the last
Does the
part.
medical power, since state laws vary state to state, across the board, does the medical power of attorney rule? Would the advice be across the board in the United States, please identify your medical power of attorneys?
Yes.
Is that the general rule?
So that would be the general rule. That is the strongest document that you can have outside of a guardianship, which I doubt you want to have someone have a guardianship over you if you have capacity. So yes, for anyone in this room, any of your friends and family, the strongest document you can have is a healthcare power of attorney, which, by the way, is different from a legal power of attorney. You can actually appoint one healthcare power of attorney and appoint someone else to take care of your finances and your house and your car payments. They can be separate people. They are mutually exclusive documents. And just because you have a financial power of attorney does not mean that they are your healthcare power of attorney. Although, under the guardianship statute, they would be considered actually towards the top of the list, it's not the same thing.
I want to, first of all, thank you for your work in this area. I drove up from Jeffersonville, Indiana. I'm a chaplain with Clark Memorial Hospital, and we're very close to Kentucky. And as you know, in Kentucky, they do have the hierarchy, and they don't in Indiana. So it's very frustrating to work in that environment where anybody can, like you say, come in from out of town and say, no, I want grandma to be on the ventilator. So thank you for working. We complain about this law all the time, so it's good to know somebody's doing something about it or trying to make a change. Secondly, I wanted to ask you about that the living will. I noticed that you mentioned as an example if somebody, you're trying to decide about the ventilator, but the living will doesn't mention the ventilator, it just mentions nutrition and hydration.
Right.
So is that because it's a recommendation only that you would assume that, if they say, yes, they want one, then they would probably want the other?
I think that's a really good question. Actually, I can't speak to the history of the living will legislation in Indiana, but I would be curious to know actually when it was put in place, if ventilators were actually commonly used at that point. Because I know the surrogate decision-making statutes were implemented in the early 80s. And so at that point, I know we had the Nancy Cruzon case where we're just trying to figure out what we're going to do with ventilators, whether we're going to allow people to even remove ventilators. And that was the whole point of the Cruzon case, was the physician said, I don't think we can remove a ventilator from this young woman because I think that's killing her. And so it went all the way to the New Jersey Supreme Court, who said no, if her family has the ability to make this decision on her behalf. So I'm not sure why it doesn't address that. That was just pulled out of the Indiana Living Will document that the state of Indiana provides. And so you can have living wills that are much more in-depth. You can get as in-depth as you want, actually. You can say, if I have a subarachnoid hemorrhage, I would like you to wait 1 month before you withdraw life support, because at that point we should have a good idea. I mean, you could tell people what your Glasgow Coma Scale score is. I mean, it's completely up to you. So it is a good point. I think that there are some problems with Indiana's living will statute because it does leave a lot of questions, maybe sometimes more questions than answers. But, if it really came down to it, I would hope that it would actually help rather than harm. So, and thank you for coming.
Angela, I just want to go over the post real quick. On your slide, it said that it was a legal document that you would initiate if there's like terminally ill patient within 6 months. But I thought my understanding was that a healthcare provider couldn't have this conversation with either a guardianship or the healthcare rep or the patient if they're not in a terminally ill state, like your elderly patient.
Sure. So as there is literally a post expert in the room, I will defer to Susan Hickman, to Dr. Hickman.
I actually had a question of my own, but so the post form is a little different than a advanced directive because it's a physician order about the plan of care, and it should be filled out in a conversation with the healthcare provider and the patient or their legal representative, and then it's signed by both that patient or legal rep, depending on if the patient lacks capacity, it's a legal rep, and the physician, and then it becomes a physician order. It's really only intended for people who you wouldn't be surprised if they died within the next 12 months. And then just to clarify, there is a healthcare representative appointment form on the back of the post, but that's authorized under the Healthcare Representative Act. It's not something different. It's just it's another version of the healthcare representative appointment form. So does that answer your question? The law states they had to have advanced chronic progressive disease, advanced chronic progressive frailty, a terminal condition, or be unlikely to benefit from cardiopulmonary resuscitation. My question is, I suspect that a lot of people in the room are wondering why on earth this bill didn't just pass with flying colors and why this is so challenging. So I'm wondering if you wanted to share what you've learned about the resistance to making any modifications to the Healthcare Consent Act, because it is considerable. And there are actually many reasons that people express concerns about making modifications. So I'm wondering if you want to address that.
Yeah, absolutely. So there were a lot of concerns with this. So and I think a lot of the concerns come out of the fact that a lot of the people who have the responsibility for passing these laws don't work with patients every day in hospitals. They don't see this every day. So one of the biggest things that people pushed back on is they said, we should let courts make these decisions. So when I gave this presentation to a group of lawyers, not to throw them under the bus, but they did step back and say, no, we need to let the courts do this. We have a mechanism in place. The courts need to determine who the guardian is. And what I found from my research and from my experiences is that does not mesh well with clinical care, and it's not even practical because it's time consuming and it's expensive to the family. So if you have a family from a low socioeconomic status background, can they afford to go and get a guardianship? Probably not. And it's going to also elicit more emotions. I mean, these people are already in a very hard situation. And it's very hard to say, now you have to go to court and you need to get a guardianship. You have to go to court and prove that you're the best person to make these decisions. And the courts have resoundingly said they don't want to make these decisions. So that's one bit of pushback, was that some people say we shouldn't be taking this, we shouldn't be doing this at the bedside, we should be doing this in court. That's where it belongs. So, and those people are entitled to their opinion, although I strongly disagree with it. There was some pushback on language of allowing close friends. So the other states have actually said close friends could be the loving, caring person by the bedside. There's many different ways to state that. And there was pushback saying, but if there's a close friend, then the example I got was, well, then your maid could make your decisions. And my response to that was, well, if your maid knows you the best and knows exactly what you want and you've had these conversations, then maybe she is the best person to be making your healthcare decisions. But that was also another piece of concern. The third piece of concern was that if we invoked a hierarchy, that it would encourage families not to talk, that someone would just walk in and say, I'm the spouse, shut everybody else down around them. But that's actually not the intention of a hierarchy. The intention of a hierarchy is to be there in the event that you cannot reconcile the people who are legal surrogates. So there are some states that have gone as far to say that the hierarchy isn't implemented unless you can't reach a majority. Or if there's a majority, there's someone if there's a tie, then there's a tiebreaker. So those were sort of the three big things that I got pushback on, which I think are things that we can actually address. And I think we can address them successfully if we can have more open conversations. This was the first time, and honestly, if you've never experienced this, all you have to go on is your personal experience, right? If you're not working with patients in hospitals, all you have is what's gone on in your family and what you know. And the fact that, I guess the fourth thing is that people said, we shouldn't legislate things that are going to make people lazy. That's what I was told. And I said, okay. And they said, people need to take responsibility, and they need to go out and they need to use one of these mechanisms. There's many mechanisms for appointing a healthcare representative. And to that I say, I don't know how you can expect people to do absolutely everything and anticipate everything. And I think when you talk to the general public, the consensus is they already assume those people could make those decisions for them. They had no idea that they actually had to have a piece of paper in order to let the person who loves and cares for them make these decisions. And so I do think that with more conversation, that hopefully we can come to a resolution. As you saw from the slide back looking at different states, I'm not asking for the law to be changed in a way that's crazy or unique or even progressive. I'm not asking to be progressive here. I'm asking Indiana to come and be with the rest of the 36 states who have the 30 states who have laws with hierarchies and expanded decision makers. Thank you.
Yeah. Oh, sorry. So with respect to patients that truly are unbefriended,
hi.
Hello.
It's like I hear your voice.
Certain states have a statutory provision that allows, I think on the consensus of 2 physicians, for an urgent but not emergent procedure to be performed. Is there any thought about pursuing something like that for the unbefriended, or is that, is that the progressive that we're not looking at?
So that actually was put into this law, or into this bill. It was saying that physicians, if there was someone who's unbefriended and they had no one, that two physicians could actually come together and make that decision for the patient. That was so progressive, I think it blew people's hats off their heads. So that is actually, that is a provision in other states. There are many states that actually say, if you have absolutely nobody who can make your decisions, that physicians can come together and make that decision for you. So that's not a unique provision, but I don't suspect that it's something that's probably going to happen in Indiana anytime soon. So I think that that's too progressive. Used it quite frequently. It does tend to be used quite frequently, and I have heard feedback from physicians who have worked in other states and came to Indiana where they've said, I just don't understand why we don't have this here. It's used frequently, it's used appropriately, and it's not abused. And I think the thought there is that it could be abused, and that physicians could say, well, why don't we just remove, the ventilator because this patient's taking up a bed. Now, there are mechanisms to do that. The state of Texas actually allows physicians to give patients, I believe it's 10 days written warning, that they're going to withdraw a ventilator because it's futile, and they have used it. So that is too progressive. I'm not asking for that. I'm not asking for death panels. All I'm asking is that more ethically appropriate people be able to make decisions for patients without having to have a legal document. So, yes. Right.
On the healthcare representative, it doesn't allow a person to make decisions about release from the hospital, and yet that's the document we most often encounter in the hospital.
Right.
And those healthcare reps make decisions all the time about placement, hospice care. We're having them sign the choice forms, the release of information forms. So that's something that we're doing. And then my other question is on the healthcare POA, you said they can make a decision about disposition of the body. Are you including like funeral arrangements then?
Sure. So whether or not you're going to take them out of the hospital and where you're going to put them, for instance. So, and that's actually not my area because I don't deal with disposition of bodies at all.
Okay.
But what funeral home you'll take them to, for instance, you would have the ability to decide that.
A healthcare POA, because I've always understood, we've always told people that the healthcare POA terminates at the time of the patient's death, and then funeral homes, I work in an ICU, so I deal with this a lot.
Yeah.
The funeral homes tell me that if the healthcare POA is a friend, but that the patient has family, then the family has to be the ones that do the funerals. So,
sure. So all the state law says, the statute says, disposition of the principal's body. So I cannot interpret. I do not feel comfortable interpreting that at this point. So that's what it says. So I guess everybody interprets it differently. But as we know in the law, when we're the way people interpret it and the way it's written can be very different. Yeah. So I'm sorry I can't answer that question.
Thank you.
We have a lot of patients here that come from out of the state to be treated. Are they, which state's laws are?
Sure. So once they're here, Indiana's law applies, which is actually a very interesting thing when you have patients who are being treated at the VA hospital. When you're at the VA hospital, you are under the federal law, and the VA hospital has they have their own system, and they actually have a hierarchy, and they have an expanded list of decision makers of who can decide for a patient. But the VA can't offer all things. So sometimes patients need to be transferred from the VA across the street to Eskenazi. So what happens when you've had a patient who's been treated at the VA and their grandchild's been making all of their medical decisions for them, and then they're transferred across the street to the Eskenazi? All of a sudden, the grandchild who's made every decision up to this point, even the decision of maybe to transfer the patient to Eskenazi, is now told, I'm very sorry, but you have to go to court and get a guardianship. Last question? Okay.
That would be my question. Your experience, if you had to
guardian, if in the case of going to the court to determine guardianship, does the court tend to pick among those array of relatives or friends, or have you seen where they've actually gone outside that?
Yeah,
and
that's a great question.
chosen a third party?
So Indiana's guardianship statute actually is a lot better than our healthcare consent statute. So our guardianship statute has a hierarchy where they say these are the people who actually we're going to select from in this descending order of priority, as it says. And believe it or not, close friends absolutely can be someone's guardian under the guardianship statute. And in fact, grandchildren, all of the people who are excluded from our healthcare consent law can actually go to court, and they're in that order, they're in that hierarchy. And they actually have the ability to say, I'd like to be the guardian, which, by the way, yields a lot more power than being someone's healthcare surrogate decision maker. Now, you could step back and say, well, it has more power because you're going to court and they're dealing with this and you're presenting evidence, and that's fine. But our guardianship statute, I would be fine if they just pick that up and put it into the healthcare consent statute, because it's honestly better than our consent statute, and it has more power attached to it. So, so I guess as that was the last question, I want to thank all of you for coming and listening to me. And I appreciate any feedback you have, even if it's negative, because if you tell me what you think and then you don't agree, then I can anticipate it, and maybe we can have a conversation and, come to some kind of consensus to do what's best for the patients in the hospitals, because that is the intention of all of this. The intention is just to do something to try to help patients and family members so that when they're having a really hard time in the hospital, they're not told that they have to go to court and deal with lawyers in addition to having a family member that's already dying. So thank you all for your time. I appreciate it.